Hi everyone, so today I want to talk about some of the bars to adjustment of status and how they are inapplicable to immediate relatives of US citizens. So let's dive right in. I think there's some background information you need to understand the essence of my video. So adjustment of status is the process of applying for a green card while still in the United States. You have to qualify for adjustment of status, and if you do, you can submit your paperwork while living inside the United States and you don't have to travel anywhere. The flip side to that is consular processing. So if you are ineligible for adjustment of status, you would submit your application in the United States, but then to complete the process, you'd have to go back to your home country abroad and complete the process there. So there are some bars to adjustment of status that prevent individuals from applying for adjustment inside the United States. Now, if you are an immediate relative of a US citizen, that means you are the spouse, child, the child has to be unmarried and under the age of 21, or the parent of a US citizen. Some of these bars do not apply to you. So what are the bars to adjustment that don't apply to immediate relatives of US citizens? Number one would be working without authorization. So if you've been in the United States and you don't have legal authority to work here, but you did, you got a job somewhere and it wasn't on the books, you don't have a social, that's okay if you're an immediate relative. The next bar to adjustment would be not currently having legal status. So you had a visa and expired, you never had a visa, you never had lawful status. This is okay from an adjustment of status perspective if you're an immediate relative. The next bar is visa overstays. So you came here on a tourist visa, you overstayed, you didn't go back to your home country, and you married a US citizen. You're an immediate relative, you're clear, you're good. This is not an issue. Another bar to adjustment would be if you were admitted via the visa waiver program. I think I did a video about this before, but there is a list of countries that if you're on that list, you do not need a visa to travel to the United States. There are still some minor requirements, but one of the aspects of that program is you don't have to go through the visa process. Now, if you are looking to adjust status and you are not an immediate relative of a US citizen, you cannot adjust in the United States if you were admitted in the visa waiver program. But if you're an immediate relative, you can adjust. It's not a problem. The next bar to adjustment is violating the terms of your non-immigrant status. So non-immigrant is really the opposite of immigrant. You don't intend to live and stay in the United States. You plan to eventually go back to your home country. So an example of this would be you got a student visa, an F1, and you worked a full-time job. Typically, that's not allowed. Or you came in on a tourist visa and you worked and you got paid. That's also not allowed. But if you are an immediate relative, this is okay. This is not a problem. Last and final bar to adjustment that I'm going to cover here is similar to one of the early ones I mentioned. If you were admitted to Guam or the Mariana Islands, these are territories of the United States, through their visa waiver program, you cannot adjust unless you are an immediate relative of a US citizen. So that's it. That's the list. Now, for most people that are not immediate relatives, this is an issue. This is a hurdle that you have to overcome. And most likely you will not be able to adjust and you will have to finish your green card process abroad via consular processing. For the immediate relatives, these are not an issue. You're in the clear. That's it. That's my video for today. If you like what you've heard and you want to see more, please like, subscribe, and double tap if you're on Instagram.